Welcome to the Permanent Change of Station podcast, a place where friends can come together, agree or disagree, and still be friends. Join attorney and Forever Miss Oregon, Lynette Perez, each week as she covers such topics as law, relationships, faith, and current events. No matter the issue, Lynette believes it's time for a permanent change of station.
Welcome to Permanent Change of Station. This is Lynette. I'm going to be taking from time to time an opportunity to touch upon important concepts within the law as it relates to the area of law I primarily practice, and that is criminal law. As many of you know, I spent a good decade of my career as a criminal defense lawyer. I have also taught constitutional law as well as criminal law to college students. And today I am a felony prosecutor prosecuting some of the most serious offenses that any community has to deal with, from capital murder to domestic violence and sexual assault cases. And I think it's very, very important for all that listen to understand just some basic concepts as it relates to why we do the things the way we do in real law, not TV law, and how even the founding fathers of our country were concerned so much about the rights of the accused that they devoted several amendments in the Bill of Rights to protect the rights of the accused. If you can imagine, back in England, before people came to this country and were under the rule of the crown, the King of England, and today we have a Queen of England, could basically send their soldiers into anyone's home without any type of warrant or without any particular cause. And so when we created the United States of America and the Constitution was created, the founding fathers of this country looked at ways to ensure that much of the abusive life and predicament that people in England found themselves under the rule of the crown would not have to face those issues here in America. And so we have several amendments, and throughout the next couple of weeks, I'm going to focus more on each of these specifics. But those particular amendments that we will be talking about are, first, the Fourth Amendment, which protects people from unreasonable searches and seizures without a warrant. The Fifth Amendment, which states that a person cannot be prosecuted or punished without being given due process. And due process is a person's legal rights under which the law, which includes being served with notice and having the right to be heard and defended and to defend himself or herself. The Sixth Amendment, which ensures that a defendant has the right to a trial that is judged by a jury of his or her peers. And during the trial, he or she also has the right to know what the nature of the charges are, have legal representation, and to face any witnesses for the prosecution. And the Eighth Amendment, in order to get out of jail, a person must pay bail. Bail ensures that an individual will return for his or her court dates. And the Eighth Amendment states that the court cannot set excessive bail. And this prevents judges from setting bail based off of personal feelings or prejudices against the defendant. And of course, the 14th Amendment, which allows all of these laws and amendments that were enumerated and applied to the federal government. It basically says that these two will apply to the states. Now, there's been a lot of talk of late, especially with the new confirmation of the newest member of the Supreme Court, that somehow she coddled criminals, and as if there is some problem or it is not proper for someone charged with a criminal offense to have a criminal defense lawyer. In fact, the Constitution of the United States requires it. And the case that made that possible was a case that was decided by the United States Supreme Court in 1963. It was a case out of the state of Florida called Gideon versus Wainwright. And the facts of that case went somewhat like this. Clarence Earl Gideon was an unlikely hero. He was a man with an 8th grade education who ran away from home when he was in middle school. He spent much of his early adult life as a drifter, spending time in and out of prisons for nonviolent crimes. Gideon was charged with breaking and entering with the intent to commit a misdemeanor, which in Florida at the time, back in 1963, was considered a felony. At trial, Gideon appeared in court without an attorney. In open court, he asked the judge to appoint counsel for him because he could not afford to pay for an attorney. The trial judge denied Gideon's request because Florida law only permitted appointment of counsel for poor defendants who were charged with capital offenses in which they potentially would be facing the death penalty. So at trial, again back in 1963, Mr. Gideon represented himself. He made an opening statement to the jury. He cross-examined the prosecution's witnesses, presented witnesses in his own defense, declined to testify himself, and made arguments emphasizing his innocence. Yet despite his efforts, the jury found Gideon guilty, and he was sentenced to 5 years in prison. Gideon sought relief from his conviction by filing a petition for writ of habeas corpus in the Florida Supreme Court. In his petition, Gideon challenged his conviction and sentence on the ground that the trial judge refused to appoint counsel and that refusal violated his constitutional rights. The Florida Supreme Court denied Gideon's petition. Gideon, using literally a pencil in his jail cell, filed a handwritten petition in the Supreme Court of the United States. And it was for the first time when they agreed to hear his case that he was appointed counsel to represent him for the very first time, and that was in front of the United States Supreme Court. So the court agreed to hear the case to resolve the question of whether the right to counsel guaranteed under the Sixth Amendment applies to defendants in state court. So prior to Gideon versus Wainwright, there was a prior decision, Betts versus Brady, which had been decided in 1942. The Betts case held that the refusal to appoint counsel for indigent or poor defendants charged with a felony in state court did not necessarily violate the Due Process Clause of the 14th Amendment. So the court, by granting certiorari to Mr. Gideon, part of the question was not only what Mr. Gideon was asking, but it was asking whether or not this 1942 case, Betts, should be overturned, reconsidered, or whatever. And so the case of Gideon was argued on January 15th of 1963, and just 2 months later, on March 18th of 1963, the United States Supreme Court, in a unanimous decision, they overturned Mr. Gideon's conviction. He was reversed and remanded, and they overruled unanimously the 1942 Betts versus Brady case. And in its decision, in its opinion, which was authored by Justice Black, who had previously dissented in the Betts case, it was held that the Sixth Amendment's guarantee of counsel is a fundamental right, essential to a fair trial, and as such applies the state's to the states through the Due Process Clause, again, the 14th Amendment. In overturning Betts, Justice Black stated that, quote, reason and reflection require us to recognize that in our adversary system of criminal justice, any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. He further wrote that the noble ideal of fair trials before impartial tribunals in which every defendant stands equal before the law cannot be realized if the poor man or poor woman charged with crime has to face his accuser without a lawyer to assist him. And so, because of Mr. Gideon's case that became a landmark United States Supreme Court case, if you are charged with a criminal case, you have a right to counsel. It's a fundamental right to have a lawyer represent you. And as we have evolved also that through Miranda versus Arizona and other cases that I will touch upon in more detail in the days and weeks ahead of this podcast, that if you are too poor to afford a lawyer, which was the case of Mr. Gideon, that a lawyer will be court appointed to represent you. It is a right that you will have to waive to be able to walk into a courtroom without a lawyer in a criminal case. It is a fundamental right. And so if there are those that think that they have an issue with criminal defense lawyers representing people who have been charged with very serious crimes or less than serious crimes, know that you are standing in opposition of the United States Constitution, because this is a fundamental right. And we should all be grateful for Mr. Gideon. This is Lynette Perez with another edition of Permanent Change of Station podcast.
You've been listening to Permanent Change of Station. Tune in each week for the latest episode on Apple Podcasts, Spotify, or wherever you find your podcasts. You can find PCS Podcast online at pcspodcast.live and on social media. And while you're at it, don't forget to rate, subscribe, and leave a review. This helps others find the show, and we really appreciate it. We'll catch you in the next episode.